Welcome. My name is Carolyn Hoytella. I'm the Director of Practice Management at Conventus Inter-Insurance Exchange. Thank you for joining us today. I'll be moderating today's webinar titled A Review of New Jersey's Out-of-Network Consumer Protection Transparency, Cost Containment, and Accountability Act. We have received many inquiries from our insured members about this new law, which significantly affects almost every physician's office in New Jersey. That's why we've developed this presentation, which provides you with an overview of the law and practical suggestions on how to implement it in your practice. Today's objectives: we will explain the key provisions of the Act, who is covered, what the definition is for non-emergencies versus inadvertent, emergent or urgent, also known as involuntary care, the disclosure requirements, the patient hold harmless and balanced billing prohibitions, the assignment of benefits and waivers of copays, and the arbitration process. We'll give you information on how to understand how the Act affects physician practices. We will explain the implementation strategies specific to physician offices. So it's my pleasure to introduce our speakers today. Today we have with us Sheila Mintz, who is an attorney at Capehart Scatcherd and is the chair of their healthcare practice and is also an experienced tax lawyer. Sheila acts as general counsel to many large and small practices and ambulatory care facilities, assisting with transactional tax, human resources matters, as well as negotiation with payers and vendors. She also handles governmental and commercial payer investigations and audits into healthcare billing and coding practices. Susan Lieberman is the Vice President of Practice Resources at Conventus Inter-Insurance Exchange. Susan leads a team dedicated to helping insured physicians and their staff meet the challenges of an ever-changing healthcare environment. She has 40 years of healthcare experience in working in the trenches of both the clinical and business side of healthcare. She has also consulted in various healthcare settings and is a national speaker. A little bit about Conventus. Conventus is a professional liability insurer formed and governed through an alliance of physicians. We are dedicated to all size groups and independent physicians. Our coverages include medical professional liability, board actions, HIPAA, fraud and abuse, and cyber liability. For our services, we have some key practice management services that are available. We have a 24/7 hotline. We have practice consulting services, as well as compliance. We provide information on legislative updates and online and on-site education, as well as practice management tools, one of which is our Conventus Out-of-Network Law Toolkit to help our insured members implement this new law. About Capehart Scatcherd. They are a full-service regional law firm with offices in New Jersey, New York, and Philadelphia. The healthcare group represents clients in healthcare business transactions, mergers and acquisitions, billing and coding audits and investigations, regulatory compliance including HIPAA, medical employment and human resource questions, as well as licensing board investigations and litigation. So here is our standard disclaimer. Please be aware that the information presented today is for educational purposes only. Statutes, laws, rules, regulations frequently change. And specifically within the out-of-network law, additional regulations to interpret the law may also be promulgated in the future. Therefore, we are not providing advice in your particular situation. We suggest that you seek advice from experts in the field, such as billing and coding consultants, specialists, and attorneys about the needs and issues pertinent to your own practice. Couple issues on housekeeping. And before we begin, I'd like to review these items. The presentation will be archived on the Conventus website sometime after the webinar concludes in about 7 to 10 days. We will also provide a copy of the slide presentation. Because we have several attendees on the line, we also have muted the lines to avoid background noise, which allows everyone to hear better. But if through the presentation, please feel free to type questions into the question window pane on the webinar navigation control panel. This is usually located on the right-hand side of your screen and can be expanded or hidden. This way, we'll be able to better tailor the materials to your needs. At the end of the presentation, we will address as many questions as possible as time allows. If we're unable to finish the Q&As in the time allotted, we will get answers to you sometime after the webinar. You will also be asked to complete a very brief survey immediately after the webinar. Your feedback is very important. Please take this time to complete it so we know what topics you'd like to hear about in the future in order to better serve you and improve the webinar to meet your needs. So now we will start with the presentation.
Hi, good afternoon, everybody. This is Sheila Mintz. So we're going to be talking today about Assembly Bill 2039, which was signed in June and went into effect on August 29th. It's called the Out-of-Network Consumer Protection, Transparency, Cost Containment, and Accountability Act, which I just generally call the Out-of-Network Act. And it applies to state-regulated plans. So for the most part, it's going to apply to your commercial carriers and not to Medicare or Medicaid, because it does not apply to federally regulated or self-funded plans. So Medicare, Medicaid, the different types of insurances that are available to federal employees, all of these would not be affected by the out-of-network law. But your normal, private pay, Aetna, Horizon, all of those things are going to be subject to the law, and it does affect almost every physician practice in New Jersey. So it's very, very important for everybody to learn a little bit about it, and actually learn a lot about it. So generally, these are the different facilities, different types of entities that are covered by the Act. We're not going to get into what the acute care hospitals have to do, or emergency departments, or ambulatory care facilities. We're really going to try to concentrate today just on the healthcare professionals and medical practices, because we get a lot of information back from clients who are saying, well, this doesn't really affect me because I'm basically in network with everything, and but in fact it does affect almost every single practice within the state of New Jersey in terms of the disclosure requirements and and other aspects of the bill. So the insurance carriers that are subject to the Act are so the state-regulated insurance plan. Again, those are the commercial payers, the HMOs, medical service corporations, multi-employer welfare arrangements, state health benefit programs, and school employee benefit programs. So basically, that the multi-employer welfare arrangement is not all that common, and you may not be familiar with it, but that's basically when a group of employers kind of set up their own plan, and everybody kicks in to cover the employees. Those are state-regulated plans also. So if somebody comes to you and says that they're involved in a MIWA, which is what many people call them, then that would be people. Those would be people who would also be subject to the Act, and you would have to do the required disclosures too. So the self-funded plans are not included in the definition of carrier. However, the self-funded plans can elect to opt in. If they opt in to the out-of-network bill, then they need to notify the banking and insurance department of the intent, and they need to issue a health insurance identification card to the primary insurer, indicating that the plan is self-funded and is elected to be subject to the Act. Both the healthcare providers and the covered individual need to know if the plan is opted in. Just a little addition to that is that there was a bulletin that the Department of Banking and Insurance issued, I think early this week or late last week, which clarified some of the issues related to the self-insured plans. So members can access the arbitration procedures through the out-of-network plan, even though you cannot, even though the plan may not have opted in. So there are some things that apply to self-funded plans, even for those plans that do not opt in, based on the bulletin that was issued by Department of Banking and Insurance within the last few days. So, how will you know which self-funded plans have opted in at this time? I mean, I think probably the easiest thing for you as a medical practice is basically to treat everyone the same, and not have a lot of different policies and procedures based on what type of insurance people have, because you may not know immediately whether a self-funded plan has opted in or or otherwise. Because so for anyone with a non-federal insurance program, I think you're better off doing across the board, complying with the law and providing all the required disclosures, even though it may possibly not apply, because I think what you don't want to do is you don't want to end up missing somebody who it should have applied to, and that seems like it's more it's more likely than if you just give the same thing to everybody regardless. So again, Medicare and Medicaid can be excluded, but not any commercial payers, and the self-funded plans also. I would just recommend doing one across-the-board policy to cover everything. So again, here are the insurance plans that are not covered by the Act. So Medicaid, Medicare, which includes Medicare Advantage plans. I know that a lot of the Medicare Advantage plans are managed by third-party payers. So you may see Horizon or Aetna or any one of those, those payers involved. But if it's a Medicare Advantage plan, it should not be part of the out-of-network bill. The out-of-network bill will not apply. Accident, credit, disability plans, long-term care, workers' comp, dental plans, obviously, PIP insurance, and the hospital confinement indemnity coverage, which I don't think arises all that often. So what the Act requires providers to do is to disclose the network status. Now, probably a lot of you have a general list, whether it's something that you hand in writing to people when they come in, or you have on your website of what plans you participate in. So you may have it at the level of Horizon or Aetna or AmeriHealth, but you really need to have it down to the actual plan name. So if it's a Horizon PPO or Horizon HMO or Horizon EPO or any of the numbers of O's and PO's that there are, all of that needs to be stated completely specifically on your website. I know that there are some practices that don't have websites, but it seems to me that the easiest thing to do to make sure that that patients are properly informed is probably to create a website if you don't have one, and put that information on there. Otherwise, you have to provide that to patients in writing when they come in. So you have to give them a handout, which is another piece of paper for the staff to remember, and may create some issues, especially as if you go in and out of various plans, or as people's insurance coverage changes. So and then you also have to provide the notification and reporting requirements, and the law also, and this is really important, prohibits balance billing of patients. and in case of a misrepresentation of network status, or an emergent or urgent service at an out-of-network facility, or receipt of inadvertent out-of-network services at an in-network facility. So again, this does not apply to patients that have knowingly and voluntarily decided to go with an out-of-network provider for their services. But again, it's going to be very, very important for you as a provider, if you have made that agreement with your patient to do knowing elective out-of-network surgeries, that they really do fully understand that this is out-of-network, and they know what their financial responsibility is. The new Adobe bulletin was pretty specific about saying just the disclosure of your participation with a plan does not necessarily mean that the patient has knowingly and voluntarily agreed to being an out-of-network payee. So that can be very tricky, and you really need to look at your toolkit. In fact, Conventus for Conventus Insured, they have a great toolkit which can give you some templates and things going forward. But if you don't have the luck to be being insured by Conventus, you would, certainly speak to your attorney or your malpractice carrier to see if you can obtain something like that you can use. So again, this bill is meant to apply only to emergency or urgent services at an out-of-network facility, or receipt of inadvertent OON services, which would essentially be things like anesthesia, radiology, pathology, all of those things that might creep in when there's a surgery in a facility related to where some of the providers are not in network. Anyway, just for the healthcare professional, the violation, the penalty for violating the law is $100 per violation, and that's $100 per day per violation. You won't be fined more than $2,500 for each occurrence, and there's a possibility of a report to the licensing board. So I would say $2,500 for each occurrence would probably relate to the patient. So if you have a number of patients who allege or where there's been some determination that you've in fact violated the terms of the out-of-network bill, you can see that this penalty might add up pretty quickly after a while. And again, similarly with the healthcare facility and the carrier, there's an $1,000 per violation penalty, and the same type of thing going forward with each day is separate. The penalty can't be more than $25,000, and reporting to the Commissioner of Health. One of the things I think that's very important to know when you're going forward with this, and it's generally an important thing to know anyway, is what is your malpractice coverage provider to, what is their policy for defense of board actions or investigations. Not every provider is it all the same at all. Some of them provide $5,000 of coverage, some provide $50,000 in coverage, some provide $25,000 in coverage. If you have a real board action, that's not really going to, that may not get you too far with legal fees and consultants that need to be involved. Sometimes there's additional riders that you can purchase that would increase that, but that's something that everybody in the marketplace, all providers should really know about, know what your healthcare, your medical malpractice carrier covers for you in that regard.
Thank you, Sheila. This is Susan, and now I'm going to go into what Sheila talked about in a little bit more detail, because Sheila gave a really nice, concise overview of this law, but we need to get into some of the details now. And I want to emphasize that we're focusing on physicians and how it practically impacts your offices. So we're not really going through all the implications for hospitals and other healthcare facilities such as ambulatory surgery centers. So I just wanted to emphasize that. So let's talk about disclosure requirements first for healthcare professional disclosures. And we're going to be talking about non-emergency situations first, not the patient who's going to the ER or that kind of thing. This is, somebody who's coming to your office. So this is what the law requires. Prior to scheduling the appointment, you have to list the participating health benefits plans and facilities you are affiliating with on your website or in writing. So on your website, if you don't, you can put, I've heard things like, well, I participate in every single insurance plan, so I don't have to list anything. Yes, you still have to list it. However, you can say, I participate in all Aetna health plans except for the following. So maybe that's a little bit of a shortcut, but you can't say just because I participate in everything, I don't have to list it. That's not what the law says. So, and again, as Sheila mentioned, is if you don't have a website, then you have to list it in writing and give it to the patient. And you're going to need to keep those lists updated. You also have a duty to disclose at the time of appointment by listing your participating health plans and facility affiliations. And law says either verbally or in writing. So you have that choice. However, from a prudent perspective, we do suggest that you always have it in writing, because then you have proof that you did tell the patient. And there are consequences to not telling the patient that we'll discuss later, but one of them is if you don't tell the patient and they go ahead with your out-of-network services, then you can't balance bill them for anything other than what in-network would have paid. So that's basically what I'm telling you, which is the next bullet down, that you have to disclose the out-of-network status. But also, the patient can request an estimated amount that will be billed. And upon request, you have to give them the estimated amount, the associated CPT codes, inform them of their financial responsibility in excess of either the deductible or copay or coinsurance, and please recommend that they contact their health benefits carrier for a consultation of costs. Again, this is down to the specific plan level. Now, let's talk about in-office procedures, or those procedures that you are coordinating. So for office-based procedures, that would be involving other providers, and Sheila already mentioned some of those might be anesthesiology, pathology, radiology, laboratory, even your assistant surgeon. You have to provide to the patient the name of that provider, the practice name, the mailing address, and the telephone number. Again, even for assistant surgeons. So we suggest that you maintain a list of providers that you regularly work with or refer to in healthcare facilities, so that you have this list available. You have to provide them instruction on how the patient can determine which plan the other providers participate in. And you have to recommend, once again, that they contact their health benefits carrier. So those are some of the things that you need to do. However, this disclosure requirement does not apply if you are a primary care physician or internist and you have an unscheduled procedure in the office. So let's say, and then you can just give it to them verbally at the time of the service. So for example, let's say someone comes in and they have a skin lesion and you need to biopsy it, and that was not contemplated originally. you can inform them of that at the time of service.
I would just add one thing to that, Susan. Sorry for the interruption, but if you do decide to do that verbally to a patient, I would make a note of that, because you always want to be able to have some documentation that at least you have told the patient. So whether you note it in the chart or in their file or someplace else, but I would certainly keep a note of the fact that you did inform them.
Totally agree. Thank you, Sheila. Okay. If you are, now we're going to go to if you are scheduling or a voluntary service at a facility for inpatient or outpatient care. You, again, will need to provide the patient with the facility name, practice name, mailing address, and telephone number of the other physicians who will be arranged for by you or who are being scheduled at the time of pre-admission. It's the same thing over again. Provide instruction on how the patient can determine which plan the other providers participate in. Recommend that they contact their health benefits carrier for a consultation on costs. And this is the other thing that you need to do. If between the time that you have scheduled the procedure and the time that the procedure actually takes place, there's any changes in status, you must notify of network status, you must notify the patient of that. And let's go into some now, based on all of what we told you, let's go into some practical action items that we suggest you implement in your offices. The first thing is, and it's very important, to have one person coordinate and manage this overall process so that it is coordinated and done uniformly. And we suggest that it's someone who knows the revenue cycle process in your practice and can manage the changes. And the physicians need to be involved in this too, because it's their care. And the physicians need to, whatever the practice comes up with, all the physicians at your practice must uniformly do the same thing. So we really want to stress that. Again, I want to say a couple things that we've seen. We've seen practices say, oh, we don't have to worry about this because it's the billing company who's managing all of this for me. No. You need to be doing this. It can't be your billing company. There's things that you need to be telling the patient, the disclosures that you need to be doing, the things that you need to be doing for your website, the forms that you need to be doing, and that's not necessarily just your billing company. Again, we also see that some of the providers are telling us I participate in everything, or I'm out of network for everything and I just don't need to, so therefore I tell all my patients. And again, you still, whether you're out of network for everything or you're, quote, in network for everything, you still must comply with all the aspects of the law, which includes disclosures before and at the time of appointment, listing of the website, and all of that. It still must be done. So we also suggest that you review the health plans you participate in, look at which ones you do not contract with and which ones you do, and remember this is down to the specific plan level. Review your financial forms. You will need a disclosure form that lists which health plans you participate in, and you might want to incorporate this into your registration packets. But again, remember, this is not just for new patients. This is for all patients. It's got to include the language on out-of-network. And I just want to say something, that you really need to obtain the signatures on all the forms and have a form, because the patient must knowingly and voluntarily use you if you are out of network. I'm going to stress this throughout the entire presentation. Sheila mentioned the New Jersey Department of Banking and Insurance. That new formal guidance came out on November 20th of this year, and I can tell you that it stresses knowingly and voluntarily. So if you just inform them or have someplace buried in your registration packet or in your forms that you give to the patients that you're out of network, that is not considered knowingly and voluntarily. You need to disclose the exact things that the law is telling you to do, and we will keep going over that. We also suggest that you develop a script for your schedulers at the front desk, or your schedulers and other people in your patient care team, and they need to know what to say when a patient calls and wants to set an appointment or needs a referral to schedule a procedure. So some of the things that you're going to want to tell them, and we have a script for this in our Conventus out-of-network toolkit, but I'll just go over a couple of things. Do you participate in the plan or not? What is their financial responsibility if you do not? And is the copay or the coinsurance due at the time of the appointment? That they need to contact their health benefits plan carrier regarding any of the charges. If they'd like to know the amount, you need to tell them that as well. What the estimated that we can give you the estimated amount, and also send a disclosure form and a copy of the estimated amount along with your financial policy. So that's just a couple things that you might want to consider. Again, ensure that the list of carriers and health plans are kept up to date, and make sure that your staff understands that and train them on this act. They are on the front lines. They're going to be the ones talking to the patients, so they really need to know about this. And again, you've got to make sure that it's posted on your website per specific plan, that you will keep up to date. And you might want to contact your webmaster to put them on notice that you're going to need to do this. If you have items posted in your office stating what you participate in, again, that needs to be kept up to date. So all lists need to be kept up to date. If you have privileges at a healthcare facility, such as a hospital, they need to inform you of the provisions of the Act that specifically apply to them and also to your providers. You need to ensure that you keep your plan participation information updated with each facility that you have privileges at, including your accurate contact information, and you need to communicate any changes in plan status with your healthcare facility. So now let's go on to what we'll call patient hold, harmless, or balanced billing prohibitions. But before we do that, we've been talking about a lot of things throughout this, and it's really important for you to understand the definitions as it is in the law, and also as it is clarified in the New Jersey Department of Banking and Insurance, what we call NJDOBI Bulletin 1814. So we've been talking about knowingly, voluntarily, and specifically selection of an out-of-network provider. The patient chooses a specific provider with full knowledge that the provider is out of network with respect to the person's health benefits plan, even though he or she had an opportunity to go to an in-network provider. Again, disclosure by a provider of network status alone is not considered a person's decision to come to you knowingly and voluntarily. Emergency services and urgent services. The bulletin now combines them and says that they are considered involuntary services, but emergency services basically follows the EMTALA law definition of emergency services, which is a medical condition manifesting by acute symptoms of sufficient severity, including substance use disorder, and it either places the health of the patient or unborn child in serious jeopardy, serious impairment to bodily functions, serious dysfunction of a bodily organ or part. In the law that came out, it did not really specifically define urgent care services, but now that the New Jersey formal guidance from the New Jersey Bulletin does, and it says that it's treatment of a non-life-threatening condition requiring care by a healthcare professional within 24 hours. So it's not immediately, but you have to do it within 24 hours. That would be considered urgent services. Inadvertent out-of-network services is healthcare services covered under a managed care health benefits plan and provided by an out-of-network provider in event a covered person utilizes an in-network facility for any reason, but the provider, an in-network provider, is not available. So that would be your anesthesiologist, your radiologist, your pathologist, your labs, and other otherwise in-network procedures. Again, this is where it really starts to add up for your patients, that they think that they go to an in-network healthcare facility and don't realize that some of the other providers may not necessarily be in-network. And now we go on to, again, can't stress enough this: knowingly, voluntarily, and specifically select an out-of-network provider. Now we're still talking about non-emergency services, if they voluntarily and knowingly and specifically select you as an out-of-network provider as a non-emergency services, then you can balance bill them. In other words, you can bill them in excess of the covered person's co-payment, deductible, or co-insurance. But you have to have, we strongly suggest that you have to have that, that disclosure form. The licensing boards, such as the New Jersey Board of Medical Examiners, may come out with a form in the future, but in the interim, you still need to have a form. And our Conventus toolkit on out-of-network law does have samples for you for our insureds. Again, if the healthcare facility must promptly, or the provider must promptly notify if there's any network changes, status changes. Now we're going to talk about specifically emergency, urgent, or inadvertent services. An out-of-network provider cannot bill the patient in excess of the deductible, copay, or coinsurance for emergency or urgent medical services or inadvertent services. I have heard that some of the providers have said, well, what if I see the patient in the emergency room and I tell them that I'm out of network, and I specifically get them to sign that disclosure form or waiver? The New Jersey Dobie Bulletin has specifically addressed that now and has said that is not acceptable. You cannot do that. That is not considered knowingly and voluntarily, because they're in an urgent, emergent, or an inadvertent out-of-network services situation at the time. So you can't do that. However, what the provider can do is still bill the carrier for that excess amount. And if there are any amounts that are disputed that are $1,000 or over, that's when you can go to the arbitration process, which Sheila will be discussing with you. So we've gone over a lot of this, but we're going to just summarize it for you. Again, you should have create a disclosure form for in office for your non-emergency services. We've already gone over what you should be saying, but I can tell you that you should get the patient's signature and date. Let's go into assignment of benefits and waiver of copays. Just do that. Okay. So now I want to say that we're specifically again talking about emergent, urgent, or inadvertent services. That the inadvertent services, and this has changed a little bit, by the way, with the new bulletin that just came out, so listen carefully. Inadvertent out-of-network services, or services at an in-network or out-of-network healthcare facility on an emergency or urgent basis, and benefits provided by a carrier shall be assigned to the out-of-network provider, and it's supposed to go directly to you. But once the benefit is assigned, any reimbursement by the carrier, like I said, should be paid directly to you. I know that that's been an issue in the past. No action is really required by the patient, and the carrier should provide the out-of-network provider with a written remittance of payment that specifies the proposed reimbursement and the applicable deductible, co-payment, or co-insurance amount owed by the person. You cannot, as an inducement, you can't, or an enticement to the patient, you cannot offer to directly or indirectly waive, rebate, or offer to waive or rebate any deductible, copay, or co-insurance owed by the patient. There are some exceptions that the new Dobie Bulletin does state, that you may waive, rebate, give, or pay, or offer to rebate, give, or pay, all or part of the deductible, if it's not offered as part of an advertisement and you're not routinely waiving, or there's no trend of waiving to entice patients to come to you rather than an in-network provider when an in-network provider is available. You need to make good faith efforts to determine if the patient is in real financial need, and that's something you're going to have to establish a protocol in your office, and all providers in your office will need to follow that policy. You need to try to collect from the patient, but it doesn't necessarily mean sending them to collections. So those are some of the things that you need to be able to do.
Yeah, I just wanted to add one thing. I know Susan's going to be talking about it, but having a financial hardship policy is really important for all medical practices. Whether she's just going to talk about that. So, but for the out-of-network. It's very important to have one that is consistently applied, because I know with a lot of practices that I represent, it's been very spotty. It's been hit or miss. That there hasn't really been a consistent policy. Sometimes it's just friends. Sometimes it's cousins. Somebody's neighbor. Whatever that kind of thing. You really want to have some kind of a process for creating a financial hardship. But the new bulletin and the law related to out-of-network sort of implements very strongly and states very strongly that you can't just routinely waive the deductible and the out-of-network policy and the out-of-network co-pays that someone would ordinarily have to pay to get them to come to you, and so that you can do the out-of-network services. That is going to be a real problem, and I imagine this is something that the Department of Banking and Insurance and possibly the Medical Board is going to look at with some specificity. Sorry, I jumped in, but
well, that's yeah. Exactly it. So you really need to have that's one of the things that other than creating your disclosure forms and looking at your website, you really need to go back and look at that financial hardship policy, especially if you're out of network, and then create payment plans for the patient as well. Have the patient sign that your financial hardship policies or your financial policies, so that they understand what their responsibilities are, and you have proof of that.
Right. I mean, you can ask them for their W-2, for their pay stub, or other types of things. I mean, people do all kinds of different things, but there should be at least some attempt to determine whether, in fact, they are in financial need, because there are people who will say, yeah, I can't afford to pay this, and yet they're living in a $2 million house on the beach. So it really is it's up to you to at least have some documentation that you've tried to determine that they are in fact have a financial hardship, whether that's unemployment or being unemployed or disability payment. Any of those things would probably be more than adequate, but you do need to have a policy which will be implemented. And it's not only just for this law, but generally across the board, it's a very good idea.
So now we're going to go into claims processing. negotiations and arbitrations. And there was a initial bulletin from New Jersey Department of Banking and Insurance, but it was a proposed guidance. And there is this new guidance that is now formal. There are some changes and some changes of wording. So especially the things that we've underlined here, I really want to emphasize because they are a change. So again, we've talked about for claims processing that the out-of-network benefits are assigned directly to the provider, and the provider will bill the carrier for services provided in urgent or an emergent situation, that involuntary or inadvertent situations. And there's two options that the carrier can now do. They can pay the requested amount, or they notify the provider within 28 days of receipt of the claim that it has deemed the claim excessive. And here's some differences. They must remit electronically or by certified mail. So they send it to your practice management system or by certified mail. And if you have a P.O. box, you need to be checking that P.O. box daily for the payment for its portion of the initial allowed amount. And the carrier will also provide additional information in text or a separate document at the same time that provides methods to initiate negotiation, which also is going to be sent at that same time via certified mail, email, and online form submission with remittance advice. Now, the out-of-network provider has the right to negotiate with the carrier for 30 days, that's it, from the date of the receipt of the carrier's notification to you. Before it said payment, but now it's saying notification. They need to your receipt of the notification that the bill charges exceeded the amount of the carrier's determined, what the carrier determined as the allowable charge. They must advise that the carrier, you now must advise the carrier within those 30 days of the intent to reject the payment, within 30 days of receipt of the carrier's notification to you, and it must use the notification method identified by the carrier, certified mail, email, or online form submission. Now, what we have seen in the past is that the carriers were saying, oh, it's 30 days from the day that we issued the check. So the New Jersey Adobe is now saying it's the receipt of your receipt of the notification, okay? And that's why we're assuming that they're saying that it either has to be done online or by certified mail, because that's a way of documenting when you received it. So now I will go on. I will hand it over to Sheila to talk about arbitration.
Yeah, so I just wanted to talk a little bit more about the out-of-network negotiation. We can just go back to the other slide, because you have to keep in mind that these deadlines and these time periods are real. They're not. They're very specific, and there's information in the new Adobe Bulletin which provides that if you do not do everything within the scheduled time, that in fact your claims will be denied. So if you want to negotiate and you want to go into arbitration, you need to be able to. You need to do everything within the stated time period. At least at this point, it may change in the future, but right now it's not changing. So you need to be aware of the 20-day rule, and there's a few different 30-day rules. So you need to look at it. It probably is a better idea to have like one person in your office who would be responsible for looking at this and be sort of the charge person in terms of timing and keeping a timeline. But you are going to need to be you are stuck to a very stringent and actual deadline on this. So now I'll talk a little bit about what happens if you arbitrate, if we can get the slide to move. Go ahead. Okay, so let's say you've gone through the whole negotiation process and you have not been able to reach an agreement with the carrier. One of the things that has happened with there's a similar bill that's been implemented within New York and Connecticut, and they have an arbitration procedure also, but it's been simplified by the fact that the amount paid to the out-of-network physician was based on usual and customary, which is usually determined to be a percentage, like a 90% of fair health. And that's really sort of weeded out a lot of the a lot of the difficulties in the arbitration. However, New Jersey has to be different, so we're not basing our decision as to final payment on anything really. So it's not going to be usual and customary. The arbitration request would be with Maximus, which is their current payment arbitrator that's used by the Department of Health. The plan, I guess, is to use them for the first year and then see what happens. But this is where it's going right now. So what happens is after the next 30-day period. So if you're notifying arbitration within 30 days of the final offer, each party submits their written submission and explains why. You explain as a provider why you think you're entitled to a higher reimbursement than what the carrier wants to pay you, and then the arbitrator reviews that, and they are supposed to issue a ruling within 30 days of the request being filed. I personally wouldn't want to bet on that, but that's the way the law is at this point. It's a little bit, the arbitrator actually has to. Sorry, we're having a little technical glitch here. The arbitrator has to really have there's some work for them to do here. It's not just go to Fair Health and decide what 90% of Fair Health is for this particular procedure or for this particular CPT code. There's more of a evidence-based review that has to happen. So they look at the training, education, experience of the provider's usual charge, the circumstances and complexity of the case, the patient characteristics, the average in-network payment, and the average out-of-network payment. So you can see that there's a lot that the arbitrator has to take into account in reviewing each claim, and you can imagine that, especially initially, until all of these things get ironed out and sort of start working in a more smoother way, there are going to be glitches going forward. So once the arbitrator makes a decision, they will award an amount, and that is supposed to be paid by the carrier within 20 days of the decision. There are some. The arbitrators generally fees will be split by the parties. Again, arbitration is not available to patients who select out-of-network for elective services. I do want to add that there's like a little bit of a new thing in the bulletin related to the out-of-network. Using arbitration for fees where a person is in a self-funded plan which has not elected to opt in. It's not exactly the same arbitration procedure, but there is an arbitration procedure for self-funded plans that have not opted in. And in those cases, the arbitration can be initiated by the patient, or it can be initiated by the carrier or the provider. But as I understand it, at least based on this Dobie bulletin, the decision of the arbitrator is not actually final and binding on the carrier. So it kind of seems like it's not worth doing at this point, but it may be something that changes. And again, the arbitration is only for emergency and urgent medical services, not elective services. But you can see that if your processes for dealing with different things, your out of network information to your patients is not adequate, or you're just using your typical assignment of benefit forms, which we know is not going to be sufficient to describe your out of network participation or not participation, that there can be issues going forward with the patient saying, oh no, in fact this was not elective, this was in fact an emergency. We've all had situations where a patient has been seen in the office and maybe an elective surgery was planned, and then there was some kind of exacerbation and the patient shows up in the emergency room. So there are always those little things that make things more tricky. So it would go back to what we were talking about initially in the earlier segment, is that it's really, really important to get as much as humanly possible in writing and signed by the patient before you go for this. But again, back to arbitration. So it's not supposed to be applying to elective services, just to the emergency and urgent medical services. So it's very, very important. Again, these are our actual, real deadlines. So everything that's in the rule, that's in the statute, and that is in the new bulletin, the guidance in the new bulletin, has very, very limited dates. So you have 20 days to negotiate this, 30 days to negotiate that, 30 days to file a claim. So you need to make sure that you are timely stamping times. If you have electronic, if there's going to be electronic communications between you and the carrier, that all of that is copied and is maintained in the record, because we all know that if a carrier can get away with not paying for something, or saying that things weren't submitted in a timely fashion, that will be likely a fallback, is that there's been some discrepancy. So in terms of compliance with the deadlines, so I think it's very, very important to keep the logs for each carrier, and be aware of what the carrier is going to, how they interpret this, because we haven't seen anything yet from any of the commercial carriers related to how they're going to interpret this. But I would anticipate just having seeing that there's always they each put their own little spin on various deadlines and how they want communications to be carried out and all of those things. So not only do you need to know what the law is in terms of out-of-network compliance, but you need to look at whatever you're getting from the carrier to make sure that you're in compliance with what their particular requirements are. So I think probably everybody's derived from this, and hopefully no one's sitting there ready to drink poison as we speak. But there is going to be some increased workload. I mean, I think there's going to be a fair amount of increased workload. It will become more systematic as time goes on, and as the law sort of blossoms and everybody understands how to handle things, and we see how the arbitration procedure is moving and all of those things. But right now, it's really important to make sure that you're in compliance, and try to keep, I would say, try to keep the one point person, because you don't want to have to train every single member of your staff on how to handle this, because some people are going to get it differently than other people. So you just need to have one person who is ultimately responsible for making sure that everything is going and everything is provided in a correct way, and all submissions are done correctly and on a timely fashion. So I would anticipate that there is going to be some decreased cash flow going forward, which I imagine is somewhat intentional because it will encourage you not to go through the other 60 to 90 days of having to negotiate and renegotiate and then go to arbitration. That the carrier is likely, hoping at least that there's going to be some, they're going to offer you whatever they want, whatever they think is reasonable to pay, and then you basically accept it because you don't want to have this revenue, the cash flow problem, which can affect the operation of your practice. I'm sure that there are going to be people who do that, and I imagine that's what that's some of the thought process involved in this. But you can kind of tell that I'm on the physician side with this rather than anyone else. But the out of network carriers are not going to have to worry about balance billing. Hopefully the other carriers are going to be sending the checks for the out-of-network services directly to the provider and not to the patients. I know that that's been a problem with a lot of my practices, is that the patients get the checks and then they decide that they'd really rather keep the money and not give it to you, and then then you have to chase people around, which is not what you want to be doing with your time. Or your staff's time. So, the rule is that they're supposed to be filing, they're supposed to be sending the payment directly to the provider, and hopefully that will occur. The balances are going to need to be manually reconciled, because as you're going through the negotiation and the offer and the arbitration process, your expected ARs are probably not going to be accurate. You can't quite know what the expected payment amount is at this point. I think as the law is implemented more and it becomes pretty much more standardized, you're going to get a much better idea of what you're going to get paid on an out-of-network basis for various procedures. But right now, no one really knows. And and then again, you have to make sure to keep up with the changes in the patient plans and the changes of your participation as you go forward. I do think it's easier just to put it on your website, because that would be notification that's appropriate under the law. But if you have to do things in writing, you have to make sure that they're up to date. So I think we're done, and we can. Oh, and Carolyn's going to take back over as our wonderful moderator.
Yes.
And ask for questions.
Yep. Thank you, Sheila and Susan, for this informative and important presentation. I'm now going to open up the presentations for some Q&As for Sheila, Susan, or myself. Please remember to type your questions into the question pane. And we are going to start and see what we have. And as a reminder, if we don't get to your question, please note we are going to post the webinar to our website within 7 to 10 days. And we will also summarize the questions that we have and give responses. So all of that will be posted. So please just remember also, you can always contact us if you have a question. So let's start and see what we have. Yes, there will be access to the presentation. We will send that out. I'm sorry. So we'll get through those. They're asking, one of the questions is, isn't there a fee to arbitrate with Maximus?
Yes, there is, and that fee is split by the carrier and the provider, unless you can show that the carrier has acted in bad faith, and then that's it. But there is an arbitrator fee, and you do have to pay it.
Is there a dollar amount we know of right now?
Not that I'm aware of.
Okay. Here's a question that, how about PIP arbitration with Forthright?
This is different from PIP arbitration.
Okay.
Unrelated.
Okay. And then a question is, how do we handle a commercial out-of-network as a secondary payer to a New Jersey no-fault insurance. They're excluded,
It's
right?
yeah, anything related. If you go back, once you get the presentation, you'll see that anything relates to like workers' comp or auto accidents or anything like that is not governed by this bill. So when you have those problems, there are other problems that are attendant to that, but these are not it. These are not those. So this really only talks about so anything that relates to an auto accident or PIP or no fault is not going to, the out of network law is not going to apply.
Here's another question. What should I do if a third-party middleman tries to come to an agreement for services offered, such as an agreement company?
It's not I'm not sure what that is. Is that like someone who's going to negotiate that down? I mean, I guess the negotiation is supposed to be between the physician office and the carrier. So I would not get involved with any third parties.
Okay. There's a question on clarifying the requirements for arbitration, that the claim amount being requested must be greater than $1,000. So
Yes.
Can you expand on that?
Yes, the amount in dispute can't be less than $1,000. So to be able to arbitrate, so you have to have it be at least $1,001, I guess, to be able to file for an arbitration. So I think they're not looking for doing arbitrations where there's really a de minimis amount involved.
Okay. And then there's a question about, can the negotiations be transmitted via Navinet or any of the portals the carrier utilizes? And
I think there's provision in, at least in the guidance, about electronic communications. So yes, I would. You can do the electronic negotiation, but again, you want to make sure that you can timestamp everything, because we are dealing with real deadlines here.
That's in the new bulletin that just came out. They are specifically telling the carriers, this is a lot of carrier direction, telling them that they must give you either the option of certified mail, email, or an online submission form if you are going to negotiate. And that must also be within that 30 days. So this is relatively new. I know in the past there was an issue with 7 days, business days from the date of the provider receipt. That has all changed. Again, this is continuing to morph through the process, but you should have a couple different ways to communicate that you are not accepting, or you want to go into a negotiation with the carrier. But Navinet is not it. It's going to be their portal of choice, just so you know. It's going to be based on the carrier's portal. So we have another one asking about multi-plans handling negotiations for Horizon, that there are about kind of third-party vendors and what's happening with that. And Sheila, I think your advice is not to, unless it's a third-party vendor for the carrier and there's some notification of that. So third-party vendors getting involved in that.
Yeah, there really is no provision in the law or in the guidance for a middleman type of arrangement. I can see that people might use that for think that that's a good way for them to make some money and start taking commissions, and maybe they're going to come and tell you that, if I negotiate with you for you with Aetna, I'm going to get you a better rate or something along those lines. But I would be very cautious about dealing with someone like that. I think the law specifically provides a negotiation between the physician's office and the carrier, and that's what I would do unless they implement something different.
And sorry, we're just reading a couple of these, just so you know, we have to kind of address your question offline and perhaps get a little bit more information. So some of them we're not we're not addressing because they are a little more involved and we're reading through them. Somebody asked, if a patient doesn't want to pay, how can you prove you tried? I'm assuming you're saying that you're out of network and the patient is not willing to pay.
Well, I mean, this happens a lot. It's not a secret for, especially for out of network people. That's why I think what Susan and I have both said in this in the presentation of getting as much written documentation of the patient's knowing and voluntary, involvement. Is that not it? No, okay. That they do understand that they are out of network and that they do understand what their financial responsibility is, will make that easier for you to pursue. If you just tell the patient and you say, hey, it's a really good idea for you to go and look it up on Fair Health, and here's some CPT codes for you to look at. I mean, I think you can. I think you can imagine that that's not going to go over or be very instructive to a significant number of patients. So I would say you want to do as much as you possibly can to sit down with a patient who's making an elective procedure and make sure that they understand that this is in fact elective. It's not it's not an emergency situation, and this is what they're going to have to cover. This is what you're going to be getting from the carrier. And if they don't want to pay, the more documentation you have is going to be, it stands you in better stead if you do need to pursue the patient.
Now, we've still gotten some more questions about, and one person has commented that MultiPlan is handling negotiations for Horizon. We're not aware of that at this point, but
No.
the law does not say anything about that third-party vendor. We can take a look at that, but the law is still the law, correct?
Right.
Regardless of who's negotiating.
Yeah, I mean, I wouldn't, I wouldn't be surprised because I know Horizon does, and many of the carriers do, have a lot of consultants and they do farm a lot of work out. However, the law provides that, so I would at least treat it with some caution and make sure that you're doing the right thing in dealing with them by going back to the carrier and speaking to your provider rep, because you don't want to be in a position where you're going to miss deadlines because you've been negotiating with the wrong person.
So, we're going to have to cut this off soon, but what we're also going to do is, at the same time that we send out the slides, we're going to send out the latest copy that we have of the New Jersey Dobie Bulletin so that you can see that for yourself. And one person has asked, just to clarify, the new New Jersey Dobie Bulletin advises that we no longer have only 7 business days to request out-of-network negotiations. Is that correct? That is correct.
That is correct, yes.
Yeah. Again, I just want to, before it said payment, now it's saying receipt of the notification, and that's why you have the certified mail, the receipt electronically. I believe, our hypothesis is that that's why they changed the second bulletin to put that wording in. One other person is asking if Horizon is still saying that they only have 7 business days from the from receipt. What do we do about that?
About Horizon having
They're still going
well,
by
yeah,
what they were doing before.
I understand that, but you can file a claim with Dobie, but realistically, I have to think that the carrier compliance with the deadlines may not be as stringent as what the provider is required to do. So I think you're just going to have to deal with the situation as it comes up. You can call, you can speak to your rep, you can make a complaint if you want to, but realistically, I think as this gets implemented, there are definitely going to be some hiccups.
And also, you can lodge a complaint with New Jersey Dobie.
Yeah.
That's something.
So great for those questions. Again, I just want to remind everybody that we will be sending out the slides and that bulletin that came out. So for those who have questions about the 30 days and also want to inform their carriers of the new process can obviously have that, and it could be a great document to share. So thank you all again for attending today's webinar, and have a great day.
Thank you very much.
Thank you.